Hello everyone, I'm Nazarat Fatima. Welcome to LiveLaw. We have discussed the arguments in the ongoing case relating Article 370 and the arguments made by Senior Advocate Kapil Sibal, which continued for 3 days. The matter is being heard by a bench comprising CJIDY Chandrachud, Justice Sanjay Kishan Kaul, Justice Sanjeev Khanna, Justice B.R. Gavai and Justice Suryakant. Today the arguments by Senior Advocate Gopal Subramanyam started and he appeared virtually. Mr. Subramanyam started with the argument that there are different methods of constitutional interpretation. One is historical argument, second is textual argument, third is doctrinal argument, and the fourth is structural argument. He said that in this matter, whichever way one looks at it, the result will be the same. He mentioned that the Constitution of India and Constitution of J&K speak to each other, exist together, and their complementary existence is the quintessence of their relationship between India and J&K. Moreover, as he argued, he said that the doing away with the Constitution of J&K is impermissible and not authorized. Then he talked about people and said that people have both the sense of being persons, but in the constitutional context, they also have a legal and juridical existence. With this, he introduced the idea of degree test or the effect test and said that by using this test, the extent of abrogation can be assessed. Mr. Subramanyam said that our constitution recognizes asymmetric federalism and as such its purpose is to take note of special conditions and special needs of people. He mentioned the introductory speech of Dr. Ambedkar, which had two themes and where he spoke about the Indian constitution being federal and also said that the people living in a state can be given special rights and privileges. He argued about the special status of the erstwhile state of J&K and said that J&K was not like any other state. Explaining his statement, he said there were reasons for it. One, J&K had its own constitution before the accession happened, and moreover the accession was qualified because people were still in the process of making their minds up. Mr. Subramanyam made a statement that the Indian Constituent Assembly maintained the highest sense of democracy and respect, and as such they felt that a decision can only be taken by the people and hence thought that it was appropriate and necessary that the will of people is ascertained. Then he said that this is exactly the reason why draft Article 306A spoke about the Constituent Assembly of J&K taking a decision. Mr. Subramanyam also said that the controversy is based on the misunderstanding that there is unilateral exercise of power possible by the President under Article 370. He said that he would take the court through some Constituent Assembly debates which are inspiring and also show what their final resolution was. He said that the text of the resolution is the answer to the case. He emphasized over the fact that India was left in no manner of doubt while acceding to it, and the erstwhile state had faith and respect for people of India and the Constitution. And the reason they looked at the Indian Constitution was because they needed special provisions for themselves. Moreover, he also laid emphasis over the fact that it was a grave concern of the erstwhile state of Jammu and Kashmir to give rights over land to people and call them permanent residents. With this, Mr. Subramanyam also said that there were conditions laid down out of which one was to have their own constitution, and they had also requested the government of India to have exceptions in the Constitution of India which could be effective under Article 370. And then he argued that the government of India accepted this request and issued the 1955 order. He said that there were also separate provisions including the autonomy in respect of framing laws. With regard to the usage of word temporary, Mr. Subramanyam said that even if the word temporary appears in marginal notes, the resolution was that Constitution of India must apply with these modifications, and more importantly, Article 1 and Article 370 must continue. He also made an interesting statement about the coexistence of the two constitutions and said that the two constitutions speak to each other from the provisions of Article 370, as it was not a repository of untrammeled power, but a medium through which the Indian Constitution would apply. He said he would call it dual obligation. He also said that Article 370 of the Indian Constitution offered the ability to frame a constitution and the ability to offer our constitution subject to special exceptions. He also told the court that on seeing those exceptions, the court will understand that it's not a simple government order and is a product of bilateralism. Mr. Subramanyam also stated that the Constituent Assembly did not want to abrogate 370 and wanted it to continue. He took the court through the constitutional orders of 1950, 1952 and 1954 just in order to show the extraordinary goodwill between India and the erstwhile state of J&K and how it was expressed. We shall explain it further in addition to more arguments that were made in the court by Mr. Subramanyam in the next part of our video. We hope the information is of help and we're able to facilitate in any way. Stay tuned to LiveLaw to know more about the matter, and if you want to read the arguments in detail, please visit our website, which is www.livelaw.in. Meanwhile, do like and share our videos and subscribe to our channel on YouTube. Thank you for watching.